Case 10. Baker, the plaintiff, versus FAA, the defendant. We find ourselves in this case in the U.S. Court of Appeals for the Seventh Circuit. Here are the facts. In 1988, this court decided in Amman, current and former airline captains sought review of an FAA order denying a petition for exemptions from FAA Regulation 121.383, the so-called H-60 rule. The H-60 rule prohibits flights under Part 121 of FAA regulations, including commercial flights of aircraft seating more than 30 passengers, from taking off under the command of pilots age 60 or older. While the FAA is empowered to grant exemptions to this rule if it finds that such action would be in the public interest, no exemptions have ever been granted. After recounting the H-60 rule's tortured 30-year history and establishing the appropriate substantial evidence standard of review, this court in Amman 1 carefully demarcated petitioners' two claims. First claim: pilots age 60 or older, meaning petitioners' proposed battery of physical and psychological tests, were no more likely to cause accidents due to sudden incapacitation or undetected deterioration of piloting skills than other pilots. The FAA rejected this claim, finding that it was not in the public interest to grant exemptions when petitioners' protocol did not surely reduce all incremental risks associated with the aging process. Although this court noted that it might well have concluded otherwise, as a matter of first impression, it held that substantial evidence supported the FAA's finding. Second one: the flying experience gained by allowing pilots age 60 and older to fly offset any increased risk of accident due to sudden incapacitation or skill deterioration, and that granting limited exemptions effectively produced a net increase or at least no net decline in safety. The FAA summarily rejected this claim. Unsatisfied with the agency's cursory treatment, this court vacated the FAA order and remanded the matter to the agency for further proceedings. On remand, the FAA again refused to grant exemptions, and an order to that effect is presently before us for review. So what's the issue? Whether on average, experience sufficiently offsets possible age-related impairment of health or skills to clearly guarantee a net constancy or increase in safety. The holding of the court. After considering the FAA's new order and both parties' somewhat flawed evidence, we cannot justify a conclusion that on average experience sufficiently offsets possible age-related impairment of health or skills to clearly guarantee a net constancy or increase in safety. Accordingly, we affirm. Let's look at the reasoning behind this holding. While substantial evidence must support the FAA's decision, the pilots, the petitioners, and the plaintiffs in this case, had the burden of showing that circumstances justify exemptions from the H-60 rule, especially given the FAA's discretionary authority to act in this area. It is a heavy burden, involving obviously daunting problems of public safety. Age discrimination may form a dimension of the issue, but safety is the dominant and controlling consideration. The fact that it is apparently very difficult to demonstrate any clear conclusion with respect to the trade-off between experience and possible age-related impairment makes the task extremely onerous for the bearer of the burden of persuasion, according to the court. When the FAA adopted its age 60 and out rule in 1959, it justified the rule by stating that there is a progressive deterioration of certain important physiological and psychological functions with age, that significant medical defects attributable to the degenerative process occur at an increasing rate as age increases, and that sudden incapacity due to such medical defects becomes significantly more frequent in any group reaching age 60. And that such incapacity, due primarily to heart attacks and strokes, cannot be predicted accurately as to any specific individual on the basis of presently available scientific tests and criteria. so that any attempt to be selective in predicting which individuals are likely to suffer an incapacitating attack would be futile under the circumstances and would not be medically sound. At the same time, the FAA also found that other factors, even less susceptible to precise measurement, also must be considered. These relate to loss of ability to perform highly skilled tasks rapidly, to resist fatigue, to maintain physical stamina, to perform effectively in a complex and stressful environment, to apply experience, judgment, and reasoning rapidly to new, changing, and emergency situations, and to learn new techniques, skills, and procedures. The progressive loss of these abilities, even though they may be significant in themselves prior to age 60, assume greater significance at the older ages when coupled with medical defects, leading to increased risk of sudden incapacitation. The pilots, the petitioners in this case, presented anecdotal evidence of superannuated pilots performing heroic deeds. You see him here in the picture, Captain David Cronin, who at age 59, on his second-to-last scheduled flight, heroically landed a Boeing 747 after a forward cargo door blew open 17 minutes after takeoff, opening a huge hole in the side of the plane. The court noted, "In the case before us, however, it is apparently not pilots who have performed aeronautical miracles who have sought exemptions, and we need not consider the arguable entitlement of such special pilots to exemptions from the age 60 rule." Also, while the petitioners made some suggestive anecdotal showings and presented impressive expert opinion evidence, they were unable to develop a persuasive statistical record comparing average risks for pilots in various relevant age categories. Petitioners, relying on figures from the NTSB, presented evidence that pilots age 60 and older had a lower accident rate per 1,000 pilots than pilots in other age groups.